no humans were harmed or even used in the video creation of this program. I created it from a script I wrote using a generative artificial intelligence platform and my own avatar of me. We hope you enjoy it. Is social media imposing a known harmful risk on children? Are the internal algorithms creating addiction and mental health issues? Is social media the new big tobacco that Lady Justice needs to regulate? Will a Los Angeles jury strip away the immunity social media platforms have enjoyed since the internet's advent and hold social media to product liability principles? Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is a look at social media companies, their immunity under federal law for most conduct that occurs on their platforms, and the current legal battles engulfing Meta in a trial over product liability for the architecture of the platforms. We will look at the federal immunity laws in the defamation and copyright contexts for online internet social media platforms, Federal Circuit and Supreme Court case law touching on the immunity's breadth, and a trial underway in the spring of 2026 in Los Angeles against Meta over Instagram as an arguably defective product for children, a product plaintiff alleges has known dangers. And we will look at the growing chorus of countries out to regulate social media for children because of perceived harms and dangers. These questions matter when we ponder some of the data we will look at, such as the fact that in 2005, 5% of American adults used at least one social media platform. In 2011, it was 50%. And by 2021, it is over 70%, indeed 72%, based on Pew data. The ultimate question we are driving to: how will Lady Justice respond in our modern internet world to social media after decades of deep immunity? But first and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true Curious Lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs. And of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program where you will see fascinating legal topics related to the CIA secrecy and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park, where due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that in fact has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education that is often technical, difficult, or stressful. So sit back and let's get going in our fascinating exploration of social media on trial. Here is the spring 2026 jury trial in Los Angeles. It is the case of KGM versus Meta over the Instagram social media platform. KGM filed suit for product liability, saying she began compulsively using YouTube when she was 6 years old, and later she began compulsively scrolling on Instagram. KGM alleged her use of the platforms worsened her depression and suicidal thoughts. Her lawsuit's theory, as expressed by her lawyer in trial: these companies built machines designed to addict the brains of children, and they did it on purpose. That was Mark Lanier, the lawyer for KGM, in his opening statement. On the other side, the defense theory. The defense argues that kids with mental health issues after using a platform is not something that equates to the platform causing it. That is, complex emotional issues have many drivers or causes. The big question we are driving to: as of the mid-2020s, has social media become this generation's big tobacco, a product used voluntarily but made to be highly addictive without warnings of its known dangers? Let's look at our agenda after that preview of where we are going. Here is today's agenda. We will look at social media platforms and the federal laws over immunity for them. This will bring us to the Section 230 immunity from the Telecommunications Decency Act of 1996. These broad immunity provisions for defamation correspond to broad ones for copyright, enacted at the same time in the earliest days of the Internet, as bedrocks to the situation of social media versus the law. We will look at state product liability personal injury tort law and see how it collides with the social media immunities. This will give us a quick product liability overview as it collides with Section 230. And we will also look at some of our domestic congressional attempts or discussions to curtail the scope of immunity, as well as foreign government regulation of social media, and how that is ramping up as of 2026 in foreign efforts to protect children from perceived social media ills. We will look at the 2026 trial in Los Angeles, which is the first of thousands of pending cases by private plaintiffs to address this issue through product liability law. Finally, we will look at the Supreme Court and its rulings that have arguably closely touched on Section 230, and algorithms as a basis for liability. We ask, has the Supreme Court touched on the issues in a way that may shape the eventual outcome? And ultimately, where is the law today, and where is it going, on the issue of social media responsibility for their platform structures and for kids' use of them? Let's start by defining social media. Here, we can have this working concept or definition. Social media is a computer-based technology that facilitates the sharing of ideas, thoughts, and information through virtual networks and communities. Social media sites allow users instant communication by written content, videos, or photos. It is not just socializing and entertainment. Instead, social media plays a role in protests, political, and social expression here and abroad. On the company side of the model, this is relevant. Social media companies' business model is one where consumers are not directly charged for their use of social media platforms. Rather, social media companies sell advertising on their platforms based on specific users' demographic profile and internet browsing history. Now, companies also sell their users' personal data to consumer product and service providers. Hence, the more time that users are engaged on a particular social media platform, the greater their exposure to advertising and the greater the profits earned by the particular social media platform. And if algorithms are individually curated to a user based on all the platform knows about that user, they can anticipate the content that will be attractive to the user and then intentionally design the system to be habit-forming. This is where the economic rub of the issue emerges, as we will explore. Here is some Pew data on social media usage. In 2005, 5% of American adults used at least one social media platform. In 2011, it was 50%. In 2021, it is over 70%. Worldwide by 2022, 4.7 billion people use social media. Now, the addictive potential of social media was observed by medical professionals as early as 2009. Research asserted an addictive paradigm in many social media users' behavior, particularly adolescents, and the Bergen Social Media Addiction Scale is now widely used by researchers and mental health professionals to identify and quantify addictive social media behavior. And in November 2021, the Wall Street Journal published in their Facebook files that Facebook's own internal research identified 12.5% of its users engaging in compulsive use of social media that impacted their sleep, work, parenting, or relationships. Government data also fills out part of this picture. In December 2021, the Surgeon General issued an advisory, Protecting Youth Mental Health, warning of a mental health crisis among young adults caused in part by their overuse of social media. The Centers for Disease Control reported a 146% increase in rates of suicide in the 12 to 16 age group since 2008, and a 57% increase in the 10 to 24 age group overall. Here is further data the Surgeon General reported, quote, "From 2009 to 2019, the proportion of high school students reporting persistent feelings of sadness or hopelessness increased by 40%. The share seriously considering attempting suicide increased by 36%. And the share creating a suicide plan increased by 44%. Between 2011 and 2015, youth psychiatric visits to emergency departments for depression, anxiety, and behavioral challenges increased by 28%. Between 2007 and 2018, suicide rates among youth ages 10, 24 in the U.S. increased by 57%. End quote. You can find that by looking online for the 2021 Surgeon General report entitled Protecting Youth Mental Health, if you want to see deeper findings and the methodology. The causal relationship is of course debated and will be seen by juries in a slew of pending cases, including the one we will look at shortly. So that is where we stand in the mid-2020 ES. But let's now return to the beginning of the internet age to see how the laws were set to allow the free development of these platforms. On our next slide, as you see here, the history that ultimately led to this federal immunity that we'll talk about really starts with state common law and application of common law principles to online behavior. This is in the era before Congress even waded in, and so one of the earliest cases is in 1995. It's called Stratton Oakmont versus Prodigy case. You who are a bit older like me remember Prodigy. It was one of the early internet companies that gave internet access and bulletin boards. Well, what happened in this case is someone went up onto a Prodigy bulletin board and made a whole bunch of defamatory comments about the plaintiff, and plaintiff did not like it, so they sued. And they sued Prodigy, saying you're liable in tort for republishing liability from the anonymous uploader. They posted it, it's true, but you then republished it on your bulletin board. You exercise control over what gets published or not published. So you are simply liable under traditional state republication principles. The theory here was the same way that if I sent a letter to the New York Times saying I think so-and-so is a blankety blank and I defame them, and the New York Times published that letter, the New York Times would have republication liability under common law principles. So what happened in New York is that Prodigy Services was held to that strict standard that's normally applied to original publishers, and it was found liable because it had involved in activity such as actively screening and editing messages that were posted on the bulletin boards. It was doing this because it was looking for particularly nasty content, porn, whatever, that type of stuff, and like the New York Times would be liable for publishing a defamatory rant by me about you. So is Prodigy under this ruling. That was the spark in the early internet years that prompted radical congressional action fast to reverse course. The theory was that because that type of reasoning had the massive capacity to really chill the development of the internet and hinder the development of this massive new technology that was opening up new means of communication and sharing of information. So that early internet company Prodigy that has died now, well, it was the cause of the modern internet world and social media world we now inhabit, at least law-wise. Not only did it die for whatever reason in the marketplace, but the ruling it engendered died too by the massive federal preemptive hammer. This brings us to Section 230. Congress enacted Section 230 of the Communications Decency Act in 1996. We see it here on this slide, and it is codified at 47 U.S.C. 23C, and this is the key language we have quoted for you. This is the core of what is central to online internet immunities today. Quote, "No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider." End quote. If you read it twice, if you have to, you see it is very, very broad in terms of absolute immunity. and further provisions provide that it ends up preempting any and all state claims based thereon. Here's the definition of what an interactive computer service is. And that's the same basic definition we're using for online service providers as we talk about this in the copyright immunity realm, which we will address soon. But basically, quote, interactive computer services, end quote, refers to information services systems or access software providers that provide or enable computer access by many users to a computer server, including a service or system that provides access to the internet, and such systems operated or services offered by libraries or educational institutions. It's very, very broad. And so what it means is it's Verizon or Cox Internet, it's Yahoo, it's Google giving search, giving email, kind of the backbone access provisions. And then in the more modern sort of Internet 2.0 world, Facebook, Instagram, Snapchat, those types of businesses that have gone a step further but are still built on facilitating communication between people over the internet. Let's go to the next slide, which brings us to the twin goals of Congress with the Section 230 immunity that Congress created in 1996. The first goal was that Congress wanted to encourage the unfettered and unregulated development of free speech online and to encourage e-commerce and its development online. In other words, the development of business and e-commerce type activities online that help everyone. The second goal by enacting this immunity provision was to, quote, encourage interactive computer services and users of such services to self-police the internet for obscenity and other offensive materials, end quote. These are two massive goals, ones that help the building of the internet as we know it, that frame the statute and its interpretation over the ensuing decades. This brings us now to one of the first major cases to come down after the law's enactment. And it's really one of the foundational cases in Section 230 law. After the enactment of the Section 230C immunity, this is the case of Zeran versus AOL. And so now we're bouncing from Prodigy, which precipitated the need to pass the Communications Decency Act provisions, to AOL, which was one of the first ones to be sued after they were enacted on a state tort liability theory. And this case involved an unhappy plaintiff because this is what happened, as you see in the facts. There was a false ad placed on an AOL bulletin board, and the false ad directed users to call up the plaintiff. And, this obviously resulted in the plaintiff receiving endless amounts of harassment and calls and whatnot at his phone number. Plaintiff was not happy, as you can imagine, being bombarded by harassing phone calls. And so the plaintiff sued AOL saying, "This is your bulletin board. My personal phone number was published on it. And it's obviously harassing. And given the content and nature of it, you should have taken it down. You didn't. And that resulted in me suffering emotional distress and other state tort-based claims and damages." Plaintiff sued, and here is what the Fourth Circuit held. Congress recognizes the threat that tort-based lawsuits pose to freedom of speech in the new and burgeoning internet medium. But the imposition of tort liability on service providers for the communication of others represented for Congress simply another form of intrusive government regulation of speech. Thus, Congress made a policy choice not to deter harmful online speech through the separate route of imposing tort liability on companies that serve as intermediaries for other parties' potentially injurious messages. The case thus held immunity, and so one of the central lines that traverses that holding, as you can see, is that AOL is simply an intermediary. It's a facilitator of communication. It is not really engaged in curating the content and editorializing the content, in publishing the content the way the New York Times makes those conscious volitional business decisions about what content it's going to publish. It's really just an intermediary. That is, it's just a service provider providing a means of communication. Therefore, if I defame you, then you can sue me. You can do your discovery, and you can find out who I am, and you can go after me the same way you have always been able to go after me under state tort law. You just can't hold the internet company liable for my words. This case is a seminal foundational case when it comes to online social media liability principles. Let's look now at how the law has developed over the ensuing years on various fact patterns in terms of this immunity line. To do that, we're going to look at both sides of the immunity line. You can see in our chart here, we'll look at a few cases where immunity has been upheld, and a few cases where immunity has been denied, and this will start filling out the constellation of case law and the puzzle, so to speak, to give you a sense of where these fault lines are. The first case in our column there is a case against MySpace, and this was a suit where a plaintiff sued MySpace saying your policy of allowing minors to register and create accounts without making sure that they're adults and not taking proper steps to make sure that these are not minors has allowed minors to create MySpace accounts. They lie about their age, and that ends up, exposing minors to communication and issues that could be dangerous or harmful to them. And you should have taken steps to make sure that minors don't sign up on your service. The plaintiff legal theory was that it's negligence and is damaging to do that. MySpace defended and said, we're simply providing a means of communication. It's not our problem. We are a service provider on the internet. And this is not something that can subject us to state tort liability for our policy decisions about how we run our service on the internet. The Fifth Circuit said, yes, we agree, and MySpace received immunity. Another example is one from the California Supreme Court in 2006. And there we have the defendant being an online discussion group blog type service that's built around women's health. Defendant was running the service and posted some third-party content, and that third-party content had been content that was allegedly attacking the plaintiffs. Here the plaintiffs were doctors critical of alternative medicines, and those plaintiffs didn't like the fact that they were being criticized for being hostile to alternative medicine. So they sued the online discussion group, and the online discussion group said, no, you don't get to sue us for state defamation tort law because we're running an online informational blog. That is, people are communicating and they're saying things you don't like. Well, too bad it's not our responsibility. The court held immunity for them, too. The final example brings us to Craigslist, and you all probably know Craigslist. It's sort of like eBay meets the classified pages of old newspapers where you can buy or sell anything, you can rent apartments, and you can do all sorts of things. It's kind of a stripped-down website that's very minimalistic, and it kind of looks like the classified pages almost. It also turns out that you can find adult services on there also, and a sheriff in Illinois was not thrilled by the fact that in his local town Craigslist was facilitating these adult services and connections between adults for prostitution. The sheriff felt that Craigslist is creating this means for people to do it, and so it's creating a public nuisance because there's all this now prostitution going on in my jurisdiction. He didn't like it, so he sued Craigslist saying that you've created a public nuisance. Craigslist again got immunity from state tort law. The ruling was that you can't regulate how Craigslist provides its mechanism and services to facilitate those types of communications between people. And so the message to the sheriff was that if you want to go after people for engaging in prostitution, then go after them. But don't go after Craigslist. And so as you can see from these cases, at least the breadth of the immunity against a variety of different kinds of state tort law theories and a variety of different sort of factual situational settings for service providers is pretty significant and pretty broad. Now let's look at the other side of our chart. We're going to look at a few examples where there was no immunity given, and we're going to assess those fault lines to understand them. The first couple cases involve Yahoo, and I don't mean to pick on Yahoo here, but it just turns out there were a couple good cases where immunity was denied. They both involved Yahoo. The first one is a user of Yahoo's online dating service. He sued when he discovered that Yahoo had created false profiles and sent other users those now defunct profiles to entice them to resubscribe. This user didn't like the fact that a false profile of him was being used to try to get other people to join the dating service, and that Yahoo had actually taken those and disseminated them. So he sued Yahoo. Basically, Yahoo said, hey, look, we're just an online service provider. This is a sort of dating platform. It's kind of like MySpace type situation. We have immunity. But the court there said, no, you don't get immunity. And the reason Yahoo didn't get immunity is that Yahoo had engaged in sort of its own business volitional decision to create content itself. Those fake profiles were created by Yahoo and then disseminated those to get people to sign up for Yahoo. That's an example of no longer being just sort of a passive neutral intermediary and being too actively involved in business decisions. And it was those Yahoo decisions that triggered state liability as opposed to the communications that may have resulted that the person didn't like as a result of it. And so that was an example of where Yahoo, for its volitional activity, could face liability and wouldn't get immunity. Another example is the Barnes case we see in the chart here. In that case, there was a false profile of the plaintiff put up, and the plaintiff complained to Yahoo. Now, a Yahoo employee said, "I promise you I will take that down, I'm sorry." But the post was not taken down and continued to injure the plaintiff. Now, this is a case where there was immunity for part of what happened and no immunity for part. Let me explain. When the plaintiff sued Yahoo, he said, "You're negligent for even allowing the post in the first place. That defamatory false profile of me that someone else posted, and you're liable because you told me you would take it down and you didn't." As to the first component, the court said no, Yahoo does have immunity. That's just like our MySpace or Craigslist case. If Peter posts a false profile about Paul, then Paul needs to take it up with Peter and not Yahoo. But the court held when Yahoo's own employee said, "Don't worry, I promise you we will take it down," and the person did not then take it down, well, then there was continued injury. Plaintiff was able to pursue a state promise-based theory because of the promise made by the Yahoo employee. So again, you see the fault line here as being involved in actual activities, which causes the service provider to actually do something. That gets the service provider involved in the content trafficking, and that can trigger liability. The final example is where Mindspring was hosting a website that infringed Gucci's trademarks. In other words, someone out there created a website and they're infringing Gucci's trademarks. Mindspring is simply hosting that infringing website on the Mindspring servers and platform. Now, it was told multiple times by plaintiff that this is infringing our intellectual property, and critical here, federal intellectual property laws, but Mindspring didn't take down the site. So Mindspring was sued on a contributory trademark infringement theory. Mindspring said, "Hold on, we can't be liable under the federal IP laws for knowingly allowing this infringement to continue because we have immunity under Section 230. But, and this is an important limit because the court noted that no, the immunity grant in Section 230 relates to state tort law. Basically, what Congress made very clear in enacting Section 230 is that it doesn't expand or limit the scope of federal intellectual property laws, and those still stand. Thus, it can't override existing IP laws, and so this is why, for your clients who may be intellectual property holders, it's easier to get recourse about content to be taken down off of the internet by anonymous folks over some web service online service providers when it involves federal IP violations. There has been a little bit of congressional action back in 2018. Then, the scope of Section 230 immunity was actually amended and narrowed to mandate that platforms take affirmative steps if sex trafficking-related content is on their services. If they don't take affirmative sex steps to remove sex trafficking content, then they lose all immunity, and they can be subjected to liability and even criminal liability. Now, that narrow amendment to Section 230 expressly didn't touch the rest of the broad immunity, so it's been taken back a bit in this specific context, but expressly not taken back further. Many in Congress are in fact questioning the breadth of this immunity and what needs to be done. And here's a quote from at least Senator Dianne Feinstein when she was speaking to all the large social media companies' general counsels in 2018. She said, quote, "You've created these platforms and now they're being misused and you have to be the ones to do something about it or we will," end quote. In other words, all this stuff is going on over your services. You're making money, you're profiting from it. You're standing back being neutral and not doing anything. But if you don't start doing something to deal with this, then we are going to. I think what she's referring to when she says we are going to is we are going to either affirmatively legislate burdens and duties on you, or we're going to start repealing the scope of 230 immunity and let state tort law now regulate you. Now, the Supreme Court at the same time has actually likened these social media services such as Facebook to traditional public squares subject to sort of First Amendment principles. And this is sort of a significant step that's raised a lot of really fascinating questions, and this comes from a case involving a 2008 North Carolina statute. I'll tell you a little bit about it. In 2008, North Carolina passes a statute making it a criminal offense for a registered sex offender to access social media sites that include children. The defendant in this case had registered as a sex offender when he pleaded guilty to a sex crime when he was 21 with a minor, and he then accessed a social media site. Then, he was charged with a violation of this law, and he challenged it under the First Amendment, saying, "You can't make a law that interferes with my free speech rights." Writing on behalf of the court, Justice Kennedy said the following, And it's very, very broad language, which could have a lot of import in terms of future cases dealing with the regulation or limits on social media platforms. Quote, social media allows users to gain access to information and communicate with one another about it on any subject that might come to mind. By prohibiting sex offenders from using those websites, North Carolina, with one broad stroke, bars access to what for many are the principal sources for knowing current events, checking ads for employment, speaking and listening in the modern public square. End quote. In other words, the internet and these social media platforms and websites, many of these OSPs, have become almost a modern public square equivalent to the traditional public square where people engage in communication and discourse. That being the case, then, it starts raising real First Amendment questions about the scope of the state's ability to regulate those sites under the First Amendment, but also those sites' obligations and to traverse and deal with First Amendment law. So this is just sort of the beginning of a burgeoning new era in terms of potential regulation on the immunities of these sites. Social media, of course, includes not just written posts and content, but lots and lots of photos and videos too, and those often trigger copyright questions. Now we're going to talk about online liability and immunities for copyright infringement occurring over the internet over online service providers' platforms. Instagram and YouTube and TikTok, of course, being the principal and well-known business that have lots of video content uploaded on it by users for viewing and public broadcasting and review and even downloading by other users. Now here Congress, just the same way Congress entered the internet fray in 1996 to regulate it with online immunity, Congress did the same thing with respect to copyright liability in 1998. And the principal statute that we're talking about is the Digital Millennium Copyright Act. It was passed at the same time, in 1998, the early internet era, to address online infringement for online service providers to deal with the fact that they may be technically liable for copyright infringement for much activity occurring over their lines and to immunize them, in effect, and give them a safe harbor from what would otherwise be tort liability for copyright. Now remember, copyright liability is a strict liability tort in essence, and so liability occurs whenever Joe Q. Public's acts of infringement may cross an OSP wire. Here's an example. When you reproduce another's work, such as when I find a photo on the internet, I download it to my computer. The act of downloading the photo to my computer, I've now infringed copyright. And when I upload that to YouTube and YouTube then reproduces it, stores it on their servers, publicly displays it, YouTube has technically infringed copyright. It's because copyright is a strict liability tort, and it's because it's so easy then for online service providers that are providing this kind of backbone technology that allows people to communicate, to get caught up and embroiled in the liability tort of copyright that Congress came in to act and legislate. That is, Congress came to deal with this issue in order to again allow the development of the internet, and so the result of that was the 1998 Digital Millennium Copyright Act. Let's look at the purpose and intent now of the immunity law here. These are quotes from the Senate and House reports in terms of the congressional intent in terms of the issues being confronted. The first one is from the Senate report. Here's what's written. Quote, in the ordinary course of their operations, service providers must engage in all kinds of acts that expose them to potential copyright infringement. Liability service providers must make electronic copies in order to host most worldwide websites. End quote. The next quote comes from the same Senate report. Service providers and copyright owners must cooperate to detect and deal with copyright infringement. Now there's limits to this though. Those who repeatedly or flagrantly abuse their access to the internet through disrespect for the intellectual property of others. In other words, we're talking about repeat infringement, flagrant infringers constantly taking advantage of others' works. Those should know that there is a realistic threat of losing that access. So what Congress was saying is we want to make sure that neutral conduits don't face liability, but if they're just going to turn a blind eye basically and allow flagrant infringement to constantly occur over their service, then you're not going to get the same immunity. We see in the DMCA in Section 512C of Title 17 of the United States Code, this is the principal safe harbor as it's known, or in other words, immunity in some sense. You could look at it in terms of online service provider protection. The general rule is that these online service providers are not liable for infringements of copyrights by reason of the storage at the direction of users.
For example, users using their service, the platform is not liable for those infringements occurring, even though material resides on their systems where three basic requirements are met.
First RT, where the service provider has in fact adopted and reasonably implemented a policy that provides for the termination in proper circumstances of repeat infringers. In other words, if you're running YouTube or Instagram and you just know that Peter is every single day infringing George Lucas's copyright in Star Wars because he keeps uploading clips and George Lucas keeps complaining about it and Peter keeps doing it, well, at some point you need to stop Peter from having access, otherwise you're going to have liability. The other aspect of the safe harbor is that the service provider must not receive a financial benefit directly attributable to the infringing activity where the online service provider has the right and ability to control the activities occurring. And the final requirement goes to sort of the level of knowledge of the online service provider, and that is the online service provider does not have actual knowledge that the material or an activity using the material on the system or network is infringing. This is an actual knowledge idea. But even if there's no actual knowledge, still the service provider must not be aware of facts or circumstances from which it's obvious that infringing activity is going on.
This is sometimes referred to as red flag knowledge. This is the idea that if you're given red flag knowledge about actual infringement, at that point you need to act expeditiously to remove content, and if you don't, then you can be subject to liability and you lose your immunity. So that was the balance that in the copyright realm Congress enacted in the late 1990s. At the same time, it was enacting Section 230 on the state tort side. The net effect is as follows. If an online service provider has content published on its site that was genuinely user uploaded, then the online service provider has no copyright liability if it lacks actual or apparent knowledge, or if it has such knowledge, but it expeditiously removes it, and if it lacks a financial benefit and has adopted a policy for terminating repeat infringers. That in essence puts a level of duty on the online service provider to engage with its content to some extent and its users and make sure that it has a system in place to at least deal with receiving complaints from rights holders, addressing them, and terminating users in appropriate circumstances. So in other words, for copyright owners, if those factors are met, and they want their copyrighted content removed, then they need to send a takedown notice to the social media site, and that's the balance that Congress struck. Rather than being able to just straight file a lawsuit, you need to reach out to the service provider, let them know about it, and give them a chance to take it down. That's the balance that's been struck. Your remedy is to get it removed before you can seek money from the online service provider, and the social media site will not be liable if it addresses the takedown notice properly. Of course, if you want to seek money from the infringer who actually uploaded it, then you can always do that. And none of these laws touch those who may upload in the first instance. This only relates to regulating, of course, service providers who have the content sitting on their servers. So we have looked at both of these very early internet immunity frameworks, designed to allow the development of the internet. And we have seen the cases that show a pretty deep moat around social media platforms. The Supreme Court has never touched the immunity laws, but it did recently in 2023 speak to some issues that undergird the Section 230 immunity laws. This case is called Twitter versus Tamnay from May 2023. Basically, relatives of ISIS terrorist victims sued Twitter. They argued, Twitter allowed content that radicalized others and led to the killings. They sued under federal laws that allow recovery for people injured by terrorism. Here is the core of it. ISIS committed terrorist acts in France, killed lots of people, and then claimed responsibility on Twitter. Family members of victims sued and said Twitter aided and abetted the crimes by failing to take action to delimit the activities on Twitter by the terrorists. But the Supreme Court rejected the argument. Now, this was not squarely a Section 230 immunity case, because it was about the level of knowledge for aider and abetter liability. But, and critical here, the court noted that Twitter was agnostic to the content. It was neutral. It was arm's length. For social media companies, that is the litmus test for immunity. So this is an important case because it casts a shadow to Section 230. It reaffirms the really broad immunity theory for social media sites that simply create platforms for speech and then sit back and remain agnostic as the rest of the world says their thing. Let's look at the detailed holding a bit more to see the possible shadow it casts into our Los Angeles Superior Court case underway in 2026. This language matters, and so here is the holding. The point of aiding and abetting is to impose liability on those who consciously and culpably participated in the tort at issue. The focus must remain on assistance to the tort for which plaintiffs seek to impose liability. When there is a direct nexus between the defendant's acts and the tort, courts may more easily infer such culpable assistance. But the more attenuated the nexus, the more courts should demand that plaintiffs show culpable participation through intentional aid that substantially furthered the tort. And, if a plaintiff's theory would hold a defendant liable for all the torts of an enterprise, then a showing of pervasive and systemic aid is required to ensure that defendants actually aided and abetted each tort of that enterprise. Here, however, the nexus between defendants and the Reyna attack is far removed. As alleged by plaintiffs, defendants designed virtual platforms and knowingly failed to do enough to remove ISIS-affiliated users and ISIS-related content out of hundreds of millions of users worldwide and an immense ocean of content from their platforms. Here, plaintiffs have failed to allege that defendants intentionally provided any substantial aid to the Reyna attack or otherwise consciously participated in the Reyna attack. And here is some important language from the algorithm discussion. Quote, defendants' recommendation algorithms are merely part of the infrastructure through which all the content on their platforms is filtered. End quote. This reaffirms the concepts that sit behind the deep 230 immunity principle. The question it leaves, since this was not a direct 230 case, is as follows. Are these tea leaves we can read on the emerging product liability theories against the algorithms? We have a sense, at least from one justice, that not too much should be read into the discussion and extrapolated out to Section 230. In this case, we got a concurrence from Justice Jackson. She specifically wrote a short one, only to make this point. She wrote, quote, and the court's view of the facts, including its characterizations of the social media platforms and algorithms at issue, properly rests on the particular allegations in those complaints. Other cases presenting different allegations and different records may lead to different conclusions. The common law propositions this court identifies in interpreting this law at issue here do not necessarily translate to other contexts. End quote. What can we say is her point? One view is that we should not draw from this that algorithms to generate content are always and forever sacrosanct in the law in all areas. That is, we should not take this case's language to conclude that Section 230 immunizes as a matter of law algorithm and other product features of the social media systems. Now, there was a companion case to the Twitter one. This is one against Google by another victim. This is the Google Gonzalez case from the Ninth Circuit. Here are the facts. Gonzalez was a 23-year-old student in France and at dinner when the terrorist event occurred and was killed. Google was sued on same theory as Twitter. Google aided and abetted ISIS by providing material support due to the platform of communication ISIS used. The district court dismissed all claims under 230. The Ninth Circuit ruled as follows. The object of Section 230's solicitude is to encourage providers of interactive computer services to monitor their websites by limiting liability. This limitation of liability had the dual purposes of promoting the free exchange of information and ideas over the internet and encouraging voluntary monitoring for offensive or obscene material. And here, publishing encompasses any activity that can be boiled down to deciding whether to exclude material that third parties seek to post online. The court ruled, plainly, an interactive computer service does not create or develop content by merely providing the public with access to its platform. A website does not create or develop content when it merely provides a neutral means by which third parties can post information of their own independent choosing online. Thus, it then held that Section 230 immunizes Google. Quote, rather than suggesting matches for dating, Google matches what it knows about users based on their historical actions and sends third-party content to users that Google anticipates they will prefer. This system is certainly more sophisticated than a traditional search engine, which requires users to type in textual queries. But the core principle is the same. Google's algorithms select the particular content provided to a user based on that user's inputs, end quote. Now that case was a direct 230 ruling, and it went to the Supreme Court. But given the narrower terrorist statute ruling of Twitter, the Supreme Court did not take up the immunity question. This leaves the scope of the immunity law for another day in another court. Here is what the United States Supreme Court held. Quote, "We therefore decline to address the application of Section 230 to a complaint that appears to state little, if any, plausible claim for relief. Instead, we vacate the judgment below and remand the case for the Ninth Circuit to consider plaintiff's complaint in light of our decision in Twitter." End quote. In other words, through procedural machinations, the issue was not present anymore, and so the court passed on it, leaving for another day the hard question of what happens when social media algorithms meet Section 230. But there was a dissent in the Ninth Circuit, a judge who spoke directly to the issues present today in products liability suits. Here is what our dissenting judge said in concluding that the claims should not be barred. Quote, "That means to me that the courts should be able to assess whether certain procedures and methods of the social media companies have created an unreasonably dangerous social media product that proximately caused damages and here the death of many," end quote. Judge Gould, the dissenting judge, also wrote, quote, "Here and similarly, social media companies should be viewed as making and selling their social media products through the device of forced advertising under the eyes of users. Viewed in this light, they should be tested under a federal tort principle with a standard similar to and adapted from this restatement language under a federal common law development. If social media companies use neutral algorithms that cause unreasonably dangerous consequences under proper standards of law with limiting jury instructions, they might be held responsible." End quote. The large point here is that judicial minds differ on the exact unreasonable danger issue that sits beneath product liability law and immunity, and whether the immunity should protect social media sites. And while the Supremes did not resolve the cases on 230 grounds, instead finding no direct aiding and abetting under the terrorism statute itself, Justice Jackson made clear the case should be limited to those facts under the terrorism statute. So at least some judicial minds are looking to potentially put limits on the scope of immunity through case law adjudications. And the full court of the Ninth Circuit refused to rehear the case. So that stands as the law in the Ninth Circuit now. And this now brings us to cases in the courts, making their way to trial on the issues of whether product liability law can escape the grip of the immunity. Here are the theories at work in the pending cases around the country. The plaintiff's theory is that harm comes not from content but from product design, the engineered engagement architecture of the system, and so no immunity and instead standard tort law applies. Specifically, the service is a product imbued with a design defect, such as reward loops, algorithmic reinforcement cycles, infinite scroll, and things like that, all of which drive an addictive product that is inherently dangerous due to the design defects that create addiction risks. And a failure to warn theory. Specifically, the social media platforms knows of the risks to minors and fail to warn, conceals risks, and downplays internal research or awareness. On the other side, the defendant's theory is that any harm is from content and that is subject to immunity. And can a digital service really be a product within the law? Instagram is not a product you buy, but a digital service like books, TV broadcast, newspapers, which are information services, not products under traditional product liability law. Further, the defense theory is that the third-party speech is republished via algorithms, and that display, promotion, or content recommendation is a Section 230 publishing activity. Ultimately, the theory argues that courts cannot punish persuasive communication designs via product liability law. So, the root question we are left with: is algorithmic persuasion a product hazard or a form of protected speech? Let's do a quick look at product liability negligence law. This is a statement of the law from California, which is fairly standard across jurisdictions. You can get the law from the jury instruction itself or the cited case law here. First, this is not strict liability. That area of product liability has already been foreclosed by courts as applied to social media, so we won't delve into the area of product liability law that is governed by strict liability standards here. Instead, we will look at product liability law stemming from negligence in terms of design defects and failures to warn. At root, a plaintiff must demonstrate the manufacturer knew or should have known of the risk and failed to provide adequate warning. A claim based on a failure to warn does not necessarily assert that the product has any physical flaws. Instead, a plaintiff bringing this claim alleges that the manufacturer failed to provide adequate warnings or instructions about the safe use of the product, and they were injured due to the undisclosed risk. For example, pharmaceuticals labels identify all potential side effects so as to not trip failure to warn standards. This also triggers general negligence law and the general duty to use care when products sent for public use cause harm. All must use ordinary care to prevent their products from causing harm. So this brings us to the first case to go to trial in the nation on social media as a product subject to product liability laws. There is the case number for you. Meta's motion for summary judgment on immunity was denied. Here is what the court basically held. First, infinite scroll, reinforcement loops, internal architecture means could cause harm and are not third-party uploads or content-based. Thus, Section 230 does not per se bar design feature claims. The court had already addressed that as a legal pillar at an earlier motion stage, where it also held that strict liability did not work, but common law product defect and design law in the realm of negligence was suited. Specifically, the trial court held that immunity did not attach because the claim was not based on the content of the material posted online, but on the features of the site itself that impose an adverse effect on users. That is, Instagram is not being held liable for third-party postings. It faces potential liability for its business structure around addictive qualities in the site that are embedded in the site. Here, fact questions about whether the harm to minors was foreseeable and whether design choices may create an unreasonable risk. Thus, the bottom line, content exposure does not equal platform architecture. So here we have a summary from press reports of the trial, so you can see each side of the case, and you be the juror now and decide, at this high level of course, the question. Let's start first with the plaintiff's theory and basic overview of evidence. First, the parents. They explain that their child's behavior changed after compulsive use. Hay testified to escalating time spent online, such as late-night use, secrecy, withdrawal from real-world activities, irritability when access removed, obsession or fixation on appearance and feedback, and worsening anxiety and depression. Next, the child, who is now an adult. The assertion is repeat checking, inability to stop scrolling even with warnings, self-comparison to online images, mood dependence on likes, comments and feedback, and disrupted sleep. Third, doctors and addiction experts and child brain development experts. Here, there are medical diagnoses as a factor contributing to the symptoms, even if not pure causation. Minors' brains are particularly susceptible to engagement-maximizing architecture, and they called out meta-corporate knowledge through documents they argue, shows awareness of teen struggles to disengage, awareness of negative mental health effects, and concerns over use reduction if architecture changes are made. The defense revolves around different issues of liability and causation, of course. Here is what we can see from evidence. And of course, this is not complete because you are getting this program in real time. Safety executives focus on tools for time limits exist and parental controls exist. The platform is for connection, not compulsion. There are huge social benefits for many users. This is about user autonomy. Next, as to medical experts, mental health is complex and has multiple factors, including the person's architecture, peer relationships, offline experiences, pandemic-era isolation impacts, and the like. And this is to break causation. Further, statisticians to explain correlation is not causation. High-using teens have pre-existing issues already, and data is totally inconsistent across population surveys. And Zuckerberg himself testified that it is a communication tool to help people stay connected with friends, share experiences and interests, and discover communities. Algorithms show relevant content that people can leave if not satisfied. It is about usefulness, not addiction. And Meta lacked knowledge that the product harmed teens as any data showed mixed results. some positive, some negative, and their studies were used to improve it, not manipulate people. People use it because they value it, rather than being addicted to it. That is, popular does not equate to a defective or dangerous one. Here is the quoted testimony we have. I'm focused on building a community that is sustainable. If you do something that's not good for people, maybe they'll spend more time on Instagram short term. But if they're not happy with it, they're not going to use it over time. I'm not trying to maximize the amount of time people spend every month. And as reported, when asked about whether he believes people tend to use something more if it's addictive, he said, quote, "I'm not sure what to say to that. I don't think that applies here." And as an aside, in 2024, he had to testify before Congress on the issue of damage to children and families who believed it was caused by social media, the lack of age verification requirements, and perceived failures to protect kids. And there he said, quote, "This is why we invest so much and are going to continue doing industry-leading efforts to make sure that no one has to go through the types of things that your families have had to suffer." This is a core central defense thesis now on trial in Los Angeles, and in other cases such as New Mexico, and later in San Francisco federal court. And despite the congressional grilling, there has not been any positive law enactments by Congress to address the issue of mediating a new level of responsibility as between social media platforms and children, so it appears Congress, unlike foreign countries, is letting this one play out in our judicial branch before our judges and juries. Here is the massive issue for the jury, the court, later appellate courts, and you, as the superjuror, so to speak. Is Instagram and social media a tool some people overused, or is it an environment that is engineered to shape human behavior? Is the design defective because it is more dangerous than an ordinary person would expect? That is sort of the plaintiff-friendly incantation of the issue and standard. Or is the product defective instead if the risks outweigh the benefits given feasible alternatives? This is broadly speaking the defense-friendly incantation of the issue and rule. We saw earlier some pending congressional flirtations with amending the law, but those have not gone anywhere yet. But let us look abroad to see how foreign countries are starting to regulate social media given their perceptions of the impact on children. First, let's go down under to Australia. There, the country has banned social media for minors. This is an outright ban for children under 16 and fines for non-compliance. It is the most stringent law to date. Across the pond in Europe, the EU has started to regulate the social media model itself because social media has risk in its infrastructure, the EU believes. This is the Digital Services Act, and under it Europe investigates and fines and requires safety redesigns. This theory sees social media as a product to be regulated. And in the United Kingdom, their Online Safety Act requires social media platforms to owe a duty like premises liability. This is akin to a duty to prevent harmful content to children, mandatory age verification, and a massive fine scheme. This theory sees social media more as a service with duties to operate responsibly. So, what is the common theme? By legislative decree, as opposed to jury findings in product defect cases, it is seen by foreign nations as an unsafe product that has particular risks for minors, and so there is a duty on platform is required to mitigate risks to minors. This is essentially big tobacco meeting social media. Now, here in our country, we have tort cases that are playing out to assess whether it should be seen as an inherently defective product or a service subject to duties of care if no outright immunity applies. And courts, especially appellate courts, will assess the lower court's Section 230 decisions. So here are the conclusions we can settle on. Section 230, immunity for social media, is incredibly broad. Copyright immunity is also incredibly broad. Both immunity laws were enacted in late 1990s to help the advent of internet before anyone knew how the internet's development would shake out. But almost 3 decades on, it is shaken out now. The breadth of immunity was arguably reaffirmed in Twitter by the Supreme Court and Ninth Circuit in Google. But the door was not shut. And it is clear that judges do not see the immunity as being so pervasive as perhaps it once was in the early internet days. Remember what our dissenting Ninth Circuit Judge Gould said? Quote, "Social media companies should be viewed as making and selling their social media products through the device of forced advertising under the eyes of users. Viewed in this light, they should be tested under a federal tort principle, with a standard similar to and adapted from this restatement language under a federal common law development.
If social media companies use neutral algorithms that cause unreasonably dangerous consequences under proper standards of law with limiting jury instructions, they might be held responsible." End quote.
Those battle lines so drawn, the internet has developed, and the algorithm-based product liability theories are now being developed factually and then tried to juries.
The big question is, will courts curtail the reach of the 230 immunity to allow products liability law to penetrate social media services as products?
Has enough time passed that courts will step in and allow regulation the same way it took decades to regulate big tobacco? Or will it be the province of dissenting judges to conclude that much? We thus have seen domestic legal regimes, and foreign legal regimes were also explored. Foreign regulation shows a growing chorus of voices that sees social media as injurious to children and in need of regulation by positive law, and in the United States by common law or congressional revisiting of the immunity standard. The ultimate question: will social media ultimately face court-based regulation under tort law theories related to known dangers, defects, and overzealous marketing of dangerous products?
We have explored the arguments on each side of the legal theory, so now you decide.
And as you decide, watch the press, as the Los Angeles case is the first. But there is also a state action in New Mexico addressing similar facts and issues, and pending cases in the Northern District of California under the multi-district litigation provisions of federal law that is getting ready to have some bellwether trials. This brings us to an end of this odyssey today, but it is not the end of the story, so watch the press. Cast your vote in your mind's eye for the theories of the plaintiff and defense we explored, and see what the jury does, and the courts in post-trial motions and appeals. And of course, there will be a part 2 to this program in the future as the dust settles on the social media wars in our courts.
Thank you as always for watching, and please reach out with any questions.